May it please the court, my name is Kyle Freeman. I represent petitioner Gerald Bostock. May I reserve 2 minutes for rebuttal?
You may.
Your Honor, we are here today to ask this court to reverse the 11th Circuit decision. That decision was incorrect for 3 reasons. First, sexual orientation discrimination is sex discrimination under Title VII, as set forth by the 7th Circuit's decision in Hively versus Ivy Tech Community College. Second, discrimination on the basis of sexual orientation is is gender stereotype discrimination, in which this court found to be a violation of Title VII. Finally, as a matter of policy, Title VII should include sexual orientation discrimination to offer the same protections to all employees. Brings me to my first argument. This court should follow the holding in the 7th Circuit Court's opinion in Hively versus Ivy.
So you wouldn't tell us to follow the holding of lower court because you're talking to the Supreme Court, but you can tell us why we should adopt that rationale?
This court should adopt the rationale of the 7th Circuit's opinion in Hively versus Ivy Tech Community College. That holding was made en banc to overrule the previous decision in Hively of the 7th Circuit.
We're familiar with it, yes.
The decision held that sexual orientation discrimination is discrimination on the basis of sex because it is impossible to discriminate on the basis of one's sexual orientation without taking the individual's sex into account. The sex of the employee is in direct relation to the sex of the people who one is attracted to. So Mr. Bostock feels that this...
So you're making a textual argument? Are you saying that some of the plain meaning of the words because of sex? Can you explain that a little bit more?
Yes, ma'am. Can you repeat your question?
So you said they're inextricably linked. So the question for us is whether the words, the actual plain meaning of the statute because of sex encompasses sexual orientation. And obviously you feel it does. Can you explain that?
I do. I believe the words itself don't include sexual orientation.
You have to say that they do. So that you have to say they encompass.
Okay.
And why is that?
Okay, it encompasses sexual orientation because the sex of the employee or the sex of the people to whom one is attracted cannot or is discriminated against when including the sex of the employee. So in other words, one cannot discriminate against one's sexual orientation without including the individual's sex.
How are you defining sex and gender, perhaps? What do you define sex to mean?
I define sex to mean the gender in which one associates themselves to be.
As opposed to the biology? Many, I think your opponent's going to, I don't know. I mean, most parties are making a distinction between biological sex you were born with and the sex you identify with socially, your construct. Why do you say that it's inextricably linked?
This sex?
Sex plus sexual orientation. Because the whole question for us is how do we define because of sex? That's the phrase in the statute.
Right. I think this phrase in the statute should be interpreted as more broad, interpretation to include sexual orientation, just as the court interpreted this statute to include sexual harassment discrimination as well as gender stereotype discrimination. I believe it's within this court's power to continue that trend and include an interpretation of Title VII or to interpret Title VII to include sexual orientation discrimination.
What do you make of the legislative history? Clearly, there's no indication that those who voted for Title VII ever contemplated that include sexual orientation. Indeed, they only stuck in sex the night before in an attempt to scuttle the bill. What do you make of this legislative interpretation here?
I believe that the Congress in 1964 didn't anticipate where this country or society's attitude towards sex would be. We've come a long way since 1964, and so I believe that now Title VII, because of sex, should be interpreted to include sexual orientation. And I believe, if you wouldn't mind me, the prior panels holding in Hively before the en banc decision made an analogy where it said discrimination on the basis of sex with whom a person associates as a form of sex discrimination, just as discrimination on the basis of race with whom a person associates is a form of racial discrimination. They were quoting Loving versus Virginia. And so I believe their interpretation and their ability to analogize that holding to the one that they made here.
I think the portion of Hively you're quoting from is there's a third kind of theory, gender stereotyping, the plain meaning of it, and then association. And I think the portion you're quoting from is from an association claim brought there, just like a white individual can have a race claim for being fired for being married to a black husband and so forth. But perhaps you're also saying that, perhaps you're also making a textual analysis about how because of sex should be read. So what do you make of that quote? What are you using it for?
The quote from Loving. I believe since Title VII only says, the actual written text says it makes it unlawful for employers to discriminate against any individual on the basis of such individual's race, color, religion, sex, or national origin. So in question here in this case is the part of sex. The question that Hively, brought forth from Loving is a question of race. And the association in Loving the question in Loving was a racial association between a husband and wife. And the court interpreted Title VII to include the racial association or the discrimination against one's association with different races.
My memory is that Loving is an equal protection case. It's a constitutional interpretation. Your opponent's going to argue that it's for Congress to interpret the statute. That certainly we interpret the Constitution, but if there's going to be an amendment of the statute, it's going to have to come from Congress.
Yes.
So how would you respond to that?
I would respond that that's how the separation of powers works. Congress would have to amend the title to include sexual orientation. However, it is in this court's jurisdiction to interpret the statute to include a more broad understanding of the statute, and as they did in Oncale and Price-Waterhouse.
Right. Since you brought up Price-Waterhouse, would you like to talk about your alternative, gender stereotyping?
Yes. So discrimination on the basis of sexual orientation, also as gender stereotyping discrimination. This court held in Price-Waterhouse that discrimination on the basis of gender stereotyping is a violation of Title VII because of sex clause. This court created a but-for test in that, or established a but-for test in that holding where it said essentially an employer who discriminates against an employee on the basis of gender stereotyping engages into sex discrimination because the discrimination would not occur but for the victim's sex.
Right.
So,
actually, the but-for language tends to help your opponent, but how would you apply that theory here?
I would apply that theory here that
But your opponent's about to argue that your client has never pled a gender stereotyping claim? It's not enough in the complaint.
I think that's a question of correct procedure, and I do believe that since Mr. Bostock was filing a pro se complaint.
Well, initially filed a pro se charge, that's right. Initially, I don't remember if he had counsel for the First Amendment complaint, but now we're at a Second Amendment complaint. So do you believe, even in the Second Amendment complaint, that there's enough, has he pled enough facts to raise a claim of gender stereotyping?
Yes, ma'am.
Why?
Yes, Your Honor. Why?
Mm-hmm.
I believe, as the decision set forth in Iqbal and Twombly,
Mm-hmm.
that Mr. Bostock we have pled enough facts to substantiate a claim for gender stereotyping.
Plausibly, right. Okay, that's exactly the standard. And why here does this complaint plausibly raise an inference of gender stereotyping?
Because had the respondent, if the respondent engaged in sex discrimination, because such discrimination against Mr. Bostock would not have occurred.
But you need to point to me in the complaint. You need to tell me what he's alleged in his complaint that is enough. Do you perhaps have the complaint with you, or?
No, Your Honor. But
can you remember some things that he said that you think raise an inference of gender stereotyping?
That at this time, Your Honor, I can't come up with that information.
Well, tell me what you remember about what the facts are here.
For the facts in this case,
Mm-hmm.
that Mr. Bostock was fired for being gay,
And what had led up to it?
What had led up to his termination?
Right, what were the facts?
That he was a gay male, then that his participation in a gay softball league was frowned upon by the employees or his employers.
And how was it? So the question is, you said frowned upon. I don't remember those words in it, but are there other words in the complaint, the facts of what he said happened, that showed he was treated differently because how their stereotype views of what a man is?
Yes, given his outstanding work performance during his employment, there was no reason for him to be fired other than the fact that his employers didn't agree with his sexual orientation. At this time, I do see my time is up. May I conclude?
Yes, of course.
For the reasons set forth in this opinion or this brief, we ask this court to reverse the decision of the 11th Circuit.
Thank you. This is Marc.
May it please the court, my name is Marc Singer, and I'm the respondent for Clayton County, Georgia. Your Honor, we are here today to ask this court to affirm the decision of the 11th Circuit. That decision was correct for the following 3 reasons. First, the overwhelming majority of courts have consistently decided sexual orientation is not covered under the definition of sex. Second, petitioner's gender stereotyping claim lacks any factual support and does not support a sexual orientation discrimination claim. And third, as a matter of policy, Congress has consistently rejected the idea of adding sexual orientation as a protected class under Title VII, and Congress can change this in the future if they wanted to. Turning to my first argument, the 5th, 6th, 10th, and 11th circuits have all consistently ruled that sexual orientation is not found under the definition of sex under Title VII.
Well, obviously, the question is whether we should adopt that ruling, because we're not bound by any of them. So the most recent ones, the most recent ones, the 7th and the 2nd and the 11th are split, so why should we adopt the rationale of the 11th Circuit?
So you should adopt even though the 2nd and the 7th are the most recent, they're the minority in this case, and as you said to the petitioner earlier, you guys don't have to adopt anything from any lower circuit, so those
That's right.
cases should not even
Right.
matter if you don't believe these cases
Right.
should as well.
So the interesting thing is that the timing is that in, I don't remember the year, not too long ago, this court handed down its decision in Obergefell about same-sex marriage. And since that time, because it said same-sex marriages were constitutionally permitted, then the 2nd and the 7th Circuit said, taking that evolving understanding from Obergefell and applying it to the statute, we now think Title VII means this. So what do you think of his argument that there's some kind of evolving understanding? We understand it more broadly now.
We as
As a country,
society?
as a court?
Well, things are evolving, I mean, that's just how the world works, but with Obergefell, that's a constitutional issue.
That's
and
right.
We're not discussing a
That's right.
constitutional issue here, we're discussing a statutory issue
That's right,
under Title VII.
that's right.
So I don't think that applies or has any standing, in this opinion.
What would you, he also made a related argument that we've had 50 years of practice with, experience now with Title VII, and there are, at the beginning, we never interpreted it to include male-on-male harassment. We never include sexual harassment, but we do now. Is this part of our evolving understanding what the words mean in Title VII?
So with the harassment, it could be, but in this case, I don't believe it is, because in a case like in Price Waterhouse, it was about harassment, but that, once again, shouldn't matter here because this is a discrimination case. That's harassment.
Right, so let's come back to Price Waterhouse in the second theory, the gender stereotype. In terms of the first theory, I understand that you believe that the plain meaning, the text of Title VII, because of sex, does not encompass sexual orientation. Why
Yes.
is that?
Why is that? Because Congress has stated in cases like King and Diaz that sex, it means the autonomy of the person,
Okay.
what you are at birth, male or woman.
Mm-hmm.
So that has no play here
Mhm.
because sexual
Mhm.
orientation is someone's preference or
Right.
partner.
So using that definition of sex, he's arguing that it's inextricably linked to a definition of sexual orientation. Can you respond to that?
Sure. So sexual orientation actually has more of a link to gender as what they
Mhm.
identify themselves as and what they
Mhm.
prefer. And that is not the case with sex. Sex is something you were assigned essentially at
Right.
birth, whether you're male or female.
Right,
And those are the only two options for
Right.
the definition of sex. Gender
Right.
has a whole spectrum.
Right.
Sexual orientation has a whole spectrum.
right.
So that has no relation to the definition of sex under Title VII.
And then, what he's saying is to define sexual orientation, you have to do it so in terms of sex. I think that's his textual argument. What would you say about that?
Well, like I have, going back to what I've stated,
Mhm.
that with gender might, if anything, go closer towards sexual orientation, like I said before, because
Mhm.
someone, in gender, there's a spectrum. You can
Right.
identify anything you want.
Sure,
So
sure.
you can identify anything you prefer sexually.
Sure,
So I think those two relate much more in that way because someone
Right.
can identify as one thing that whatever they suits
Right.
them and they prefer, and going off that, their sexual orientation can be anything they prefer. So it doesn't relate back to whether you're a man or a woman because sex only worries about man or woman. Sexual orientation and gender are now worrying about the larger spectrum of your
Right.
identification.
I think what he just argued was that we define sexual orientation by the attraction that is between, in his case, between a man and a man, and we can't make that definition without talking about sex. I think that's part of his argument. The question is, if we look at the actual text of the language of the statute, why does it not encompass sexual orientation?
So if you look at the plain language of the statute of Title VII, it singly prohibits employment discrimination based on race, color, religion, sex, and national origin. Nor does it mention sexual orientation.
Right.
So it goes back to all those where race is specified. Someone's African American, Caucasian, Asian, and so forth. Same thing with all religions that people observe, and their national origin and background.
Right.
So it's more cut and dry, these definitions, than there are for what sexual orientation is and what gender is.
Why don't we talk a second about the legislative history? You're telling me that you think the words don't encompass sexual orientation.
Yes.
What can we take away from the history of this act, the legislative history, Congress's actions on it?
So Congress's actions have continued to find that sex does not encompass sexual orientation. And as I said before, and also relating back to the 10th Circuit case in Bibby, Congress went on to say, the 10th Circuit went on to say that Congress has not yet seen fit when pointing out that this is Congress's decision, that Congress has yet to find sexual orientation to fit under the meaning of sex under Title VII.
Perhaps the hardest question here is the gender stereotyping claim, because that's such a powerful, as you yourself said, genders has a much more fluid meaning. But I understand you believe they have not pled it. Could
Yes.
you speak to that?
Yes, Your Honor. So, turning to the gender stereotyping claim, it does lack any factual support, and as well, it doesn't support a sexual orientation discrimination claim if there were to be one. And so, as the 11th Circuit held in Chanda, just checking a box in an EEOC complaint, as in petitioner did here, doesn't really state anything besides you just physically check the box.
But that was the EEOC charge. It was pro se. I don't remember what the First Amendment complaint. First complaint was pro se, but now we've got a Second Amendment complaint. Do you think the facts he's pled in that sufficiently raise a claim that he was stereotyped based on his sexual orientation?
So are you asking me about gender stereotyping or sexual orientation gender stereotyping?
I'm asking you whether his most recent complaint supports a claim of gender stereotyping.
Okay. No, Your Honor, I don't.
Okay.
The Sixth Circuit held in Vickers, there was an employee's gender stereotyping claim was insufficient there because there was no factual evidence to support that he had gender nonconformity behavior, and that's the same case here. Petitioner just stated that there's a gender stereotyping claim without providing any facts, and in the Second Amendment complaint, he even changed the facts that were stated in the First Amendment complaint. And he added that on after the fact. So it was just a way to, in his mind, support a sexual orientation discrimination claim.
But what about those facts? Doesn't he say that there were comments made? I'm trying to remember. I don't have the complaint in front of me. What does he allege? And why is it not enough?
So I know what you're pointing at, Your Honor. So petitioner does allege that there are claims made in a meeting he was not a part of. So he was not there to witness it or experience it, where there could have been remarks made about him. But there's no evidence supporting that. It's just his word against another.
Well, at this point, on a motion to dismiss, it's not a matter of evidence or proof. We just have to take the allegations as true if they plausibly raise a claim. So the question is, does he say what the comments were about? What kind of specificity have we got in this complaint?
Not much at all. He does state, I guess, his actions leading up to this complaint, but in doing so, petitioner does not state any specifics in any interactions or any specific things said by any person in his office or anyone he came in
Right.
contact with there.
I think he's relying probably mostly on timing,
Okay,
that you can raise an inference of pretext from close timing. And he's arguing I was a great employee and now all of a sudden I go in this league and it outs me and I'm fired. Do you think the timing here raises enough of a gender stereotyping claim?
no, I do not believe so, Your Honor. The timing, I mean, there's coincidences. It could just happen. There could have been something else going on in Clayton County, Georgia's employees. There could be downsizing. There could be anything of the sorts. So you can't just rely on the timing of this issue.
Mhm. I've asked you a lot of questions. Is there anything you'd like to address or go to policy at this point?
So turning to my third argument,
Sure.
as I stated before, Congress, being the legislative branch of the United States government, they intended the term sex under Title VII to mean a biological male or female and not one's sexuality or sexual orientation, referring back to the King case. And that meaning that man or woman, as we discussed earlier, male or female, that's your biological identification from birth, and then as you go forward, you can identify a different gender. But this is Congress's issue to resolve. And furthermore, the Fifth Circuit stated in Diaz that one of Congress's main goals was to provide equal access to the job market for both men and women. And the definition of sex applies to the autonomy of a person, either being a man or a woman. So as more cases have continued to state that this is a Congress issue, Congress should be addressing this. And as a separation of powers, Congress is the legislative branch. This is a statutory issue. This is an issue for them to address. And similarly, the 10th Circuit in Bibby, as I described earlier, they discussed that the possibility of amending Title VII to incorporate sexual orientation under the definition of sex, as I stated before, that Congress has not yet seen that fit. So that's also showing that another circuit case, another circuit, the 10th this time, is describing that this is Congress's job.
Yes.
And it's them solely to rely on this, and that's who will be making the decisions going further about this issue. May I conclude, Your Honor?
Yes, you may.
For the foregoing reasons, we ask this court to affirm the decision of the 11th Circuit.
Thank you.
Thank you.
Okay, any rebuttal?
Your Honors, I have one point on rebuttal. Respondent suggests that sexual orientation is not linked to sex, that sex and sexual orientation are not inextricably linked, but rather suggests that sexual orientation is linked to one's gender. So if we take that as true, that sexual orientation and gender are the same, then I'll turn to this court's decision in Price Waterhouse that held recognized sex discrimination as discrimination on the basis of a person's failure
Yes.
to conform to a certain set of stereotypes.
And there's no
gender
question.
stereotypes.
But the point he was making is that while that in general is true, and that's his weakest link, that here your client didn't plead it. That's what he's saying.
Did not plead gender stereotyping.
Right.
I believe in the Second Amendment complaint that the facts set forth in that complaint were enough to satisfy a charge of gender stereotyping. The previous courts had opportunity to dismiss that complaint, and they have not done so. So I believe it's this
Actually,
court's jurisdiction.
if I'm remembering correctly, I may be confusing circuits. I thought your case, a circuit court concluded that you had waived the issue going up on appeal. Though in real life you are arguing it right now, but why do you believe that Second Amendment complaint actually has enough?
I believe the Second Amendment complaint has enough facts to substantiate the gender stereotyping claim because establishing it in the amended complaint and setting it forth for to be decided by the judge was.
But it comes down to facts. So he said all that was pled was that there were comments at a meeting. It doesn't say what the comments were. And he argued that the timing is not close enough to really raise an inference that his joining the league was the reason they fired him. Do you agree with that?
No, Your
Okay,
Honor.
why?
I do see my time is up. If you'd like me to answer your question.
Yes, please.
I do not agree that the argument that that respondent makes, the facts set forth in the Second Amended complaint, that there aren't enough facts to substantiate that he was fired for joining the softball league. I believe that's incorrect. The Second Amendment complaint has alleged many facts that support that claim for gender stereotyping, such as the reasoning that the meeting that was held where the language was used that I guess painted him in a bad, or Mr. Bostock in a bad picture, and it established the employees of Clayton County as holding his sexual orientation as the sole reason for his firing.
And then for all these reasons?
For all these reasons, we ask that this court reverse the 11th Circuit Court's decision.
Thank you.
Thank you.